So, okay, we are back on the
Yes, sir.
last leg. The last thing we want to talk about on the legislation is Section 5. Section 5, I'll share screen and we'll see. This is Section 5. So 3 and 4 had put limitations. Then 5 says the provisions of the Section 4 and provision of Section 4 and so much of the provisions of Section 2 of Section 3 as relates to the length of the pregnancy and the opinion of not less than 2 registered medical practitioners shall not apply to the termination of a pregnancy by a registered medical practitioner in a case where he is of opinion formed in good faith that termination of such pregnancy is immediately necessary to save the life of the pregnant woman. What is the impact of this clause, this section, subsection, this section? Can this be done beyond the period of 20 weeks?
Yes, it can be. The abortion can be done.
So
Can be done if the life of the woman.
This is restoring the status quo as was in IPC. So 3 and 4 are putting limitations on IPC, but under expanding the scope under IPC, but then limiting also by putting limitations. But exceptional circumstances where woman's life is at stake, this is better categorically pro-life of the woman over the life of the what we consider as a child, because above the age of 20 weeks of pregnancy and beyond, now we're talking about 24. We're all talking about that it was the it was a life versus pro-life argument, that the fetus has developed much more fully, the heartbeat has come into being, and therefore it's an independent entity in itself. But Section 5 categorically overrides the limitations of the duration as such. Now, looking at the whole legislation as a whole, what do we gather? Does it create any right in the woman over her body, autonomy over her reproductive rights and reproductive organs or her body? Can we say woman has a right to abort in India?
Yeah, up to 20 weeks, yes, we can say the women have that right to abort. But only married women.
Is that Jitendra again?
No, Shani Kumar Gautam.
Shani, you tell me, is there a difference between enabling provisions and provisions which create right? So, for example, look at the unmarried woman who is sexually active and becomes pregnant. And she wants to use explanation 2, failure of contraceptives. Or a married woman who has not used the contraceptives and become pregnant. Can she say, I have a right to abort the fetus till the age of 20 weeks or 12 weeks for that matter?
In case of
No, it's not.
There is no right.
That will be the
No, it's not a right.
It's not a right. It's an enabling provision that if you want, in these circumstances, with these limitations, yes, you may abort. It's a concession granted. There is no right to abort. It was that, well, okay, we were we had unprotected sex, whether married or unmarried. And just on that ground, they will have to either fake it, to say we used contraceptives and it failed. And therefore, we have come under explanation too. And certainly because of our policies, we will not ask them to provide proofs of that. And also this whole thing about corroboration, etc., is not required at all in these circumstances. But the fact of the situation is that going by the technical language, if somebody wants to be honest and said, I had unprotected sex and I want abortion, this is not what the law permits. So then the whole other question has been this whole question of the new the amendments that are being proposed, and I think they've been also cleared by the Lok Sabha. I do not know whether they've been passed by Rajya Sabha also or not, but I did read the newspaper which said it has been passed in Lok Sabha. So what is it that the new provision provide for? Presently, what we have was till the pregnancy of 12 weeks, one doctor, till the pregnancy of 20 weeks, two doctors, and now we are saying a board to decide beyond the 20 to 24 week period. So now from two doctors, it has gone to a board, and they will also have to again constitute. And also in case of rape, etc., sexual abuse categories of pregnancies, the abortion can be directed up to the 20 weeks by one doctor. That's what we're provided for. And then we have said unmarried women can also seek abortion. So in the present category, the only category which limits the enabling provision to married women is explanation 2. But in all other cases, if it's a woman subject of rape, certainly doesn't make a difference whether it's married or unmarried. When it says subsection 3, account may be taken of the pregnant woman's actual or reasonable foreseeable environment. So whether this will include.
If we look at the legislation, especially at explanation 2, which is presently the policy in vogue, the legislation in vogue, we can see there is no provision for an unmarried woman to get pregnancy, because the whole act has been seen through the glasses of marital relationships. The explanation 2 completely says that in case where the pregnancy occurs in result of a failure on device or method used by, this is very, very important, used by any married woman or her husband. So here the woman is qualified as married, therefore it completely separates out the women who are unmarried. Therefore, in practical terms, what it has trickled down, that at abortion centers, if a unmarried woman wants to get an abortion, she has to fake a husband. That is what is practically happening, because the act doesn't take into consideration any unmarried woman and only looks at with the four corners of a marital society.
Whether this provision, even the one which says married woman or her husband, one of the two has used the protection and it did not work. Whether under the present law, a married woman requires the consent of her husband for seeking abortion in these cases, even in the legitimate category, in the not legitimate, in the categories legally provided for. Whether she needs consent of her husband.
No.
No, ma'am.
In
will the
law,
doctors,
it is no.
Yeah, but will the doctors do the abortion without the consent of the husband?
Ma'am,
what about the reproductive
In
rights of the
practice,
husband then? No, you are correct that this one doesn't require. So if the
But they
woman
generally
goes,
don't.
no, but what will be the
in
logic? What will be the logic of those doctors to say no, we will still want the husband's consent? And whether
patriarchal
doesn't require is
mindset,
one thing,
patriarchal.
but should the law require his consent? Suppose, take the other case. She wants to continue with pregnancy. The husband says, I do not want you to carry on with this child. I want you to abort. Whose decision? How do you decide this dispute? If there is a husband and wife, the wife wants to continue with the pregnancy, and the husband says this has happened due to the failure of the device we used, not to want to children. I don't want to have children. I'm not ready for children at this point of time, and therefore you must abort. If the dispute is before you, how will you decide that dispute?
The
Ma'am, I
first
think it
thing,
is the
ma'am, I will send
personal
them to
right.
mediation.
No, the mediation is not working. That's why they are before you. If mediation had worked, we would not have been faced with the problem as our lawyers.
And this has been a lot of this issue is a lot of opinions are divided. Roe versus Wade, Planned Parenthood hood cases, which are like still debated. 1970 cases, 70
No, but
cases,
those cases are on the
1970
very right
decided, but it's
itself.
still
Those cases
decided.
are Roe versus Wade, etc., or cases on the very right of abortion. We are not on the right of abortion at all.
Yes.
We are granting that this is the enabling. We are in a country which enables in certain circumstances. So in this one, we are saying that she can seek abortion on this ground. But what we are posing the question is that she doesn't want abortion, but the husband says, sorry, I'm not ready. We have still put the obligation to maintain children on the father. And assuming the woman is not capable economically to look after the child, the husband says, I do not want you to carry on with this pregnancy. Now, should she be forced to go through adoption and abortion?
She cannot
No,
be
I think
forced to go
it is
through,
the
ma'am,
personal.
she cannot
Yeah.
be forced to go through an abortion, because that will itself constitute as a crime under IPC.
Yeah, that will be
So-
qualified as miscarriage.
Right. So
Ma'am, and
then,
it is a personal
then
right
are
of
we
a woman to give
obligating?
birth to a child.
Then we are obligating a non-willing parent to look after a child which was unwanted. Will that be in the best interest of the child? One is her wish. What about the right of the unwanted child? Will the child be looked after well?
Yes, ma'am. Yes,
Should
ma'am.
that be a consideration in deciding the question? And by that argument, we're also asking the question of the gender selection. Because all cases of female feticide are happening because these parents, both fathers and mothers, prospective mothers and fathers, do not want to have a female child. They do not want to have a female child, and that child will be unwanted. So if we say in this case that because the father is an unwilling parent, but he will be obligated to look after, provide maintenance to this unwanted child, if that is the argument, then the same argument will extend further to the unwanted daughters.
Ma'am, in this case, a father or a mother is not allowed to know the sex of the child before her birth. So the question doesn't even arise.
I know we are
if
not,
that
they're not
person is-
allowed to, but we do
They're
know
not
as a
allowed. So they
reality.
would not know if it is a female child or a male child if we go through what the legality says.
Yeah, but the demand is that we should have a right to know. Is it part of
And
my
it is
reproductive
not
right?
legal to know, but it still happens. Sex determination, it happens also. Though it's illegal, but it still happens.
Look, there are three things.
The
One is
question pertains
the
to
law doesn't permit. Second one is it does
Yes.
still
Yeah,
happen. The
but
third
couple
one
can
is
go abroad and can have the child.
yeah, the third one is
Yes,
should
that
it
is
be
there.
permitted?
That is there. A couple can.
No, that's a question. There are three questions. One aspect we know clearly that Indian law doesn't permit. We also know the reality that in India it does happen. The third one is that
Yes.
number of countries do permit. So they do not have a problem in letting the parents know what gender, what sex a child will have. So whether the Indian parents should have the right to know the sex of their child.
Ma'am, we have to also take into account the issue of female feticide, that because of that one cause that the parents know about the sex of the child, and there has been n number of cases and a social narrative that female childs are killed. Therefore, that was the sole reason by which this sex determination was closed. Even
Yeah.
constitutionally, if we are looking at it, if we go into Article 15.3, the state has rights to make special class, special rules for women and children. So even if we see that, yes, the state is trying to protect children, create a balanced ratio between genders, then the state is allowed to make such rules where the parents would not know what would be the sex of the child before the child is born.
Yeah, so that is general rule, that because we do not want daughters and therefore we made the law. But suppose there is a special case in which they say, I have 3 sons and I've been wanting to have a daughter. And I'm telling you the real case. We had a cousin who had 3 sons and we had a neighbor who had 3 daughters. Both of them were pregnant around the same time. So they actually made a deal at that point of time. All this was not the discussion, but they said that if this time also I will have the 4th daughter and you will have the 4th son, we will exchange, because we so desperately want the other sex. And as the factual things turned out, that both of them had daughters, so the exchange did not take place. But this was a case where one family was desperate to have a daughter, another family was desperate to have a son, and they were not in favor of any abortions. They will go through the pregnancies. They said, whatever happens, if this happens, then we are going to exchange our children. Because I so desperately want a son, you just desperately want a daughter. So there may be some of those families. So can we say that in 100% cases, even if somebody says, okay, I'm not going to abort whatever is the sex, but I want to be better prepared. I want to be better prepared to determine that, what kind of clothes, what kind of things, what kind of setup I should have. I have a very clear idea. If my son is born, then I will decorate my house in this manner. If a daughter is born, I will decorate my house in this manner. These are the kind of clothes, the things, attached with the child. I'm also all excited about it. So should we not permit it to some parents who want to do that?
Ma'am, I would say no, because I would apply doctrine of proportionality. In
Mhm.
considering the doctrine of proportionality, the interest of a single person is much, much lower than the interest of the whole society at large,
General public.
especially looking at female fertility side.
Mhm.
Yes.
Yeah, so the other 2 legislations we are going to look at. One is certainly the PCPNDT Act, preconception and prenatal sex determination legislation, and the other one is the Maternity Benefit Act. Both of these we are going to look at, and the cases already on these points, which I'm raising today. They are coming from the constitutional right to know the sex. I have a right to know the sex of my child because I want to plan my family well. So you are saying family planning, and then I do not want to have a tilted family. All kinds of considerations are there. And whether the legislation, there was a constitutional challenge to the PCP and the legislation as well. And the other one is the supportive nature of the law, which is facilitating pregnancy, etc. So are there any other last minute comments you have?
Ma'am, even if somebody is challenging it as a constitutional rights, still the doctrine of proportionality will apply, that not every fundamental rights or even rights are like absolute. It has to
Mhm.
come at some cost. Therefore, I go back again to my argument that proportionality has to be seen. Personal interest and a societal interest where female feticide has been a perennial problem of a Southeast Asian society. Female childs have been killed. Therefore, there is a static constitutional provision 15.3 where state can make several special groups, special laws for women and children. If we see this, the holistic argument would be that yes, for single individualistic interests, they will not be allowed to determine the sex of the child. But yeah, there would be options. They can go abroad into the countries, which is a legal loophole, and find out their sex of the child.
Mhm. Okay. So if we were to do the feminist analysis of these 2 legislations, what is it that we can say? These legislations are providing, I know these legislations are looking at women as who these women are, what to what extent these laws are useful for women, what kind of power does this law give to women, what kind of restriction this law put on the women. From that perspective, what will be your thoughts on any of these aspects? What is the nature of these laws? Are these symbolic legislation? Are these substantive legislations?
There are some part of the legislation which are substantive. If we compare, for example, if we do a comparative analysis with the laws of different countries, even if Roe versus Wade or the abortion laws in Ireland or Nordic countries, we would see that the abortion laws in those countries do not even allow abortion. There was a far cry and UN human rights case on this, which happened in Ireland. And but in India, there are laws which allows abortion for women, and the law is slanted towards the human towards women and their rights. Some part of it are substantive, but a larger part of the law is just on the face of it.
And what do you mean by that? How will you substantiate that
For
statement?
example, the ma'am, for example, the explanation 2, which doesn't allow or give rights to the unmarried woman to terminate pregnancy. In order for that, practically they have to fake a husband, because that only talks about a qualified qualifier for a woman that is married and her husband, which is mentioned in explanation 2. Therefore, the pregnancy termination centers, they do not allow, or practically they need to have a fake husband for that. So that part of the legislation which needs change, where no qualifiers for women, married, single, that is needed. So that is one thing which was only on the face of it, but there has been nothing substantive towards it. But then there is other part where a woman is allowed for abortion, which is not available at many countries. So there are parts of it, small parts of it, which are substantial, but a larger part of it is only on the face of it and needs a nuanced approach toward a feminist approach towards deciding what would be the criteria set for our societal discussion, what will be the criteria set for putting a just legislation which is substantive in its nature itself.
And also, ma'am,
yeah,
we have to see the law with respect to the time when it was legislated. So, with respect to time, it was a very forward-looking legislation in terms of when the women right discourse was actually developing. The 1970s, this feminist movement, and people are getting aware about the kind of rights, the what kind of societal vices which women actually faces. And with respect to that, law can be said as a forward-looking. Yeah, obviously, but in the current context, need certain amendments which can include the various rights which cater various classes of women, married and married, along with plus and also can take the very ethical questions of terminating life of child uh, when it legislating about termination. So yeah, it will further seek some changes, but I will say with respect to time, it was a forward looking.
Yeah, but we are now introducing in 2020 some amendments. So what is the nature of those amendments? Are they changing the nature of the law from enabling to creating rights? If even today we are not creating right, then we are not moved. We are making the practical changes which were demanded, but we have not moved in the direction of creating any substantive rights of the women on their body. If you were to say that, okay, till the pregnancy is of 12 weeks, any woman can go and seek abortion. Stop. There's no limitation on that. Then we would say that we are at least granting absolute autonomy of to the women over their bodies. But even in 2020, we're not doing that. We are still saying the same limitations. The board has to, the doctor has to advise, the two doctors have to advise, and the board has to advise. The decision making is not with the woman. The decision making of abortion is with the doctors.
Because many of the rights women, many of the decision women do not take. It is taken by the family. So it sometimes it goes against women actually. So that is why state is intervening by means of its legislation, so that women rights should be protected.
Yeah, but at the same
I would
time,
like to add a point in this.
Shani,
like to
if
add
we
a
are
point
taking
on this.
that position, then we would be wanting change in the liability, criminal liability on her. That if we are saying that the doctor's intervention is required to protect her from her own family, if we are saying this is a reality, which is true, if that is the reality of the woman's decision making, that they cannot make decisions themselves, and therefore we want a third person intervention to secure her rights, then she should not be criminally liable when abortion is done contrary to the provisions of the law.
Yeah, obviously there's various conflicts are there, man. But
So what is that we are asking? Are we saying that their criminal liability should be taken away, or we are saying they should be given absolute rights over their body? Maybe the limitation that, okay, beyond a certain point you cannot. But if at least to certain weeks of pregnancy, you have absolute right to decide to go with it or not to go with it. And the resultant consequences when it comes to the married woman, then balancing the rights of the husband, of the father to the children, and the right of the woman over her body. There are two sets of competing rights when it comes to the woman's autonomy over her body. One is the right of the unborn child, which this case, which we discussed today. What was the name? Suchita Srivastava. In Suchita Srivastava, the judges talked about the right of the state interest in the right of the unborn child to be born. So in that one, it is comparatively clearer position a lot of us take, that because the childbirth is through the process of using the human's body, woman has to have absolute right over that decision. But in her becoming pregnant, there's another human being which is involved. So to what extent that other human being's opinion should count? That's very important question. Because if we say his opinion is not required because it is her body, she has to do the consequences, but she also has certain marital obligations. So if she says, I do
Ma'am,
not
I
want to
have
produce any
yes, ma'am.
child and we will adopt. The husband says, no, I want us to have our own child. And it is not a case where they cannot have their own child because she is becoming pregnant. So she aborts against the wishes of the father. Then what are the implications in the family law arena in terms of mental cruelty to the husband? Whether the husband will succeed if he was to file a case seeking divorce on the ground of mental cruelty because the wife is aborting a child, which she doesn't want for whatever reasons, but he desperately wants. Whether his reproductive rights should then overbear the autonomy rights of the woman over her body. That's also another conflict. So there's one conflict between the unborn child, because that child doesn't exist. So we'll say that child's interests are subservient to the human being who is alive. But what about the other partner's rights over this unborn child? And we're not talking about there are physical complications or anything, but she kind of has her own ideology or her own reasons for saying, no, I do not want this child. So how, as a judge or as a lawyer, would you look at this proposition where the woman wants abortion and assuming that law does grant that right? How would you balance the right of the of this partner, maybe a husband, maybe a partner? How do we balance the interest and the rights of this other person who has contributed in the pregnancy? So that's a thought I leave you with, unless you have something to add.
Ma'am, I have a question.
Yes, please.
When we were talking about section 5, that we were talking that these are enabling provisions, but if we look at that, for example, a woman, if she's having some fatal impairment which endangers the life of that particular woman, but stating that the rights but she has the rights to bodily integrity and reproductive autonomy.
Mm-hmm.
So I think that in that instance she has the right to preserve her own life and avoid that the danger with that pregnancy. So there is a right to that instance or not?
There's not even a right even then. Because
Ma'am, I
that
have
also
a
is, no,
question.
that is also opinion of the medical practitioner. It's not her right, her decision. She doesn't know. So that is
Ma'am, I have
also
also a
enabling the
question on
doctor
this.
to commit to that, to the abort. If the doctor doesn't
Ma'am, I
agree
have
with her, She says, I am a
Yes.
single mother, single unmarried mother. I'm going to be subjected to a lot of ostracism. I do not want to have this child. The doctor still have to take that call, na? She cannot say, no, no, this is my right, you have to abort. They say, I'll make up my own mind. The decision making is not with the woman in that provision. Decision making in
Then
all
at
abortion,
what
but
part we are
consent is
talking
required.
about Article 21 then? Like then what at part we are talking Article 21 that personal liberty she has sexual that she has that reproductive autonomy to that instance when I think it has created a barrier for that if we look at some particular cases, for example, an unmarried woman that you were saying that she'll be a scrutiny and ostracized from the society. Then again, the board has to decide that whether she can terminate the pregnancy or not.
Yeah, even without the new amendments, when you look at Section 5 you were referring to, it is still saying the opinion of the medical practitioner. So all the decisions of pregnancy termination are not with the woman. She can make a request. Whether it will be granted or not is not her decision. So that's where, that if she had a right, the doctor would have a duty to do it. But it is not. He has to take a decision on what she says. So the doctor's argument will be that, well, you knew of these consequences. You are an adult. You took this decision to be sexually active. And you knew that the possibility of pregnancy can't be ruled out. So take the consequences now. I cannot help you.
Surely.
Yeah, so that's something we are not giving the control to the woman.
Ma'am, another thing to explore is that even with the new amendments, the state is still looking at pregnancy through the concept of marriage. The state is still denying to look that Simon de Beauvoir in her book Second has written that perfect child can be born without love or marriage. So, but the state still looks at childbirth through the lenses of marriage. There's a possibility of even premarital sex or premarital pregnancy that is totally denied by the state, and state has completely taken its eye off that, and all the legislations include the ostracises the single woman, the unmarried woman, and there is nothing in the MTPA Act which allows her to take a qualified consent on herself to terminate the pregnancy. It has always to be a qualifier with married woman or a
Yeah, it's not only married or unmarried, it's also the appropriate word is single woman. So she may be a widow. She might be a divorcee.
yes woman.
So she's not in that sense unmarried. She's not the virgin category woman. But the law is
The
still
state,
very much
even
on
its
the moralistic
amendment,
category. The abortion is still
yes,
in
ma'am.
the
That's what I
moral
was saying. The
category.
state, even in its amendment, is bringing the moralistic category in it and not getting into the biological and pragmatic approach towards how the law should be. It still ostracizes a huge number of groups of women who would not fit into married woman category.
Yes. And the same goes, it's not limited only to pregnancy. Now, we've seen this in all other categories also when we talked about adoption, we talked about surrogacy. It's very, very moralistic that children and family is very clearly heterosexual, and it is with the marital ceremonies. When a union is created with those in heterosexual capacities and through the ritualistic ceremonies, only then you can have sex, only then you can have children. So the conception that you can have children without these two trappings is not thought of. So certainly it's a newer area, but certainly it was also not thought of that a mentally retarded woman would want to retain a pregnancy which has occurred to her due to rape. So this is completely unthought of by the law. But the realities of life are much more beyond what the law conceives and perceives. So the examples are now becoming manifold that the law has not conceived of those situations. And the law, when it was made in 1860, then it was made in 1970, had its own trappings of that time. But even in 2020, we're refusing to move out from the morality limitations of heterosexual marriages and sex and children within those marriages. We still have the same law which says illegitimate children, children born out of the wedlock. So we have not moved away in saying human beings are born through a natural process of heterosexual intercourse. And now, of course, not even that much. Now we have IVFs. We have, suppose a woman goes through IVF, a single woman goes for IVF, sperm donor. And she realized that she has become pregnant with 4 children instead of 1. She wants to avoid that pregnancy. This was wanted pregnancy, but she doesn't want to have 4 children. But the IVF does result into triplets and twins and 4 and 5, and I don't know how many children now women are, some of them are having because of IVF. The law doesn't consider those situations. That she wanted this pregnancy, but not so many pregnancies at the one go. So if she wants to have abortion on that ground, law doesn't have to think of those situations. So there are a lot of situations which are arising because of newer ways in which we are living life. The technology is developing, the medicine is developing, the new techniques are developing, but law is still very much far behind, even on those scientific developments. The one development of sex determination was done for a very different purpose, but it is being used in a very different purpose. So this is a constant struggle between law and society. When is the law ready to bring about the changes, and whether society is ready to actually accept the change which the law provides for. So, okay, we'll stop today on this. We will look at the other legislation, the Maternity Benefit Act tomorrow.
And surrogacy.
Yeah, we should look at surrogacy guidelines also. We're not listed that, but certainly we should do that. So, okay, we'll meet tomorrow then at 2 o'clock.
Okay, ma'am.